would they have the opportunity to appeal via federal courts? I mean, this isn't normally going to go through a state appeal, but you brought up even the Second Circuit as a venue that had previously held the Sixth Amendment violation applies in context of failed notice to the defendant of what their crime actually is. Given the vagueness around what the underlying crime really was, or the third step of the cascade that you talked about earlier, if it still relates to a federal campaign finance allegation, are they limited to the New York system's Court of Appeals line, or are they actually able to get out and get into federal court for appeals here too?
Normally, the way it works is they'd have to go through the state appellate courts. Yep. They have to appeal to the appellate division, then appeal to New York's highest court, which happens to be called the Court of Appeals, but that's like New York Supreme Court. And only then could they appeal to a federal court, namely the United States Supreme Court. And of course, that would take years. And the United States Supreme Court would not issue a final ruling, potentially reversing this conviction until years after the election, which is a very serious problem. You brand somebody a convicted felon, that could change the outcome of the election. That could affect the election of the next president of the United States. And we'll never get a federal court to actually rule on these serious constitutional issues until long after the election. That's, in legal terms, that's irreparable harm. And that's why I've said that, if I were the lawyer for the Trump team right now, I'd be running to federal court right now, file suit under Section 1983, and say, you got to pause those proceedings in the state criminal courts, and we got to give a chance for the federal courts to review these serious constitutional objections. Now, it gets harder and harder to do. Once you've got the jury reaching a verdict, it gets harder and harder to claim that a federal court can hear this case. You have to overcome certain abstention doctrines and other doctrines. But I think there's actually some good arguments that in these extraordinary circumstances, a federal court should look at this to avoid irreparable harm. And, that can actually be done fairly quickly. You move for a TRO, an emergency temporary restraining order, whichever way the judge comes out on that. You could appeal to the Second Circuit, and whichever way the Second Circuit comes out on that, that could go to the Supreme Court. That could all happen on a kind of a fast-track basis. I wish we could get a federal court to hear this, because the country kind of needs that. You can't just have this kind of thing resolved by New York courts deciding the case under New York law. They should be looking at constitutional law, but so far, as far as I can tell, Judge Mershon hasn't really been doing that.
And could the Supreme Court itself make that determination right away? Or,
well, I'll tell you,
ordinarily they would wait to run its way through New York, but they could just take and grant cert now.
Well, it's conceivable. There are certain emergency doctrines you might try to take advantage of, but no guarantee. It's tough. Yeah. I'll tell you what, though. If another state sued New York, there's only one court in the country that has jurisdiction, exclusive jurisdiction, over a suit by one state against another, and that happens to be the United States Supreme Court. They cannot bring their case in a state court, a federal district court. You can only bring that case in the United States Supreme Court. A state attorney general, in principle, could bring a case against the state of New York right now and say, this is an unconstitutional conviction. And, we know what you're going to do is very likely you're either going to incarcerate or impose probation. That's, very, very likely. And that's going to hinder Trump from campaigning in our state. And that gives us an injury, and that gives us standing. And we want to litigate whether this conviction was constitutional. That's a long shot. But
I kind of like that a lot, actually. It's very interesting.
It could be done.
I mean, there are states, the citizens of that state are harmed by their ability to adjudicate who the president of the United States should be, which is the prerogative of voters.
Well,
New York stopping them from doing it. Yeah.
Think if they incarcerated him. The minute they incarcerate him, he cannot go to federal court anymore, and he's stuck in a jail waiting for the New York courts to decide if they're going to stay the sentence, or, you don't know what's going to happen. But if, God forbid, he should, New York dared to incarcerate the leading presidential candidate from the other party, that would prevent him from campaigning in other states. And that would clearly, I think, be a First Amendment violation of the citizens in other states if the underlying conviction was unconstitutional, if it was unlawful. And, that would be something that federal courts should adjudicate. And in theory, a state could bring that case to to the Supreme Court as a matter of the Supreme Court's original jurisdiction.